Okay, welcome everybody. Thank you for being here. I'm Lori Rosen. I'm a judge in domestic relations. I think I know many of you or have seen or met many of you before. I've been sitting in the division since 2019, but I am not the person we care about today. We have three fabulous judges with us who are going to be our panelists. I'm just sort of moderating, and I think everybody has received the hypotheticals ahead of time that we're going to focus this CLE on. And what we really did was try to come up with a variety of scenarios that we can sort of sink ourselves into. And it's your opportunity to ask the judges for feedback on how they would handle things or what they would do or what their thoughts are about how the law applies to the different situations. So this is all meant to be really interactive. We hope that everybody's participating. I think just based on how many people there are here, the best option is when you do have questions or when we do ask for feedback or along the way, if you think of something, put it please in the chat. We can monitor it. I can monitor it. And that way we'll be able to address everything. And then if you need to raise your hand in a Zoom way, you can all do that too. But I think that's probably the easiest ways is just by communicating through the chat. So first we have Judge Bernadette Garrison Barrett. She was elected as a circuit court judge back in 2022 and came to the Division of Domestic Relations shortly thereafter. Since April 2023, she's been assigned here and specifically now is on calendar 21 and 54. I think that's Team E still, if I recall, in the Daly Center. She also sits on the Supreme Court's Committee on Access to Justice and the ISBA Family Law Committee. Before taking the bench, Judge Barrett was an attorney who practiced in Illinois for almost 3 decades. Her practice concentrated mostly on divorce and family law litigation, civil litigation, and corporate matters. And she earned her JD from Loyola University School of Law. So did I. And her Bachelor of Science from DePaul, her undergrad. And she's also admitted to the federal bar for the Northern District of Illinois, as well as the Supreme Court of the United States. In regards to our other two panelists, we have Judge Brad Trowbridge, who's also elected in 2022 and is currently assigned as well to domestic relations for at least the last 3 years. Prior to being admitted to the bench or elected to the bench, he also practiced his practice on family law and served as both a GAL and a child representative, as well as a custody evaluator, which would be great if we had more of those now. So I guess he left us all hanging by taking the seat on the bench. Prior to attending law school, Judge Trowbridge had earned a master's degree in human development counseling and was a therapist and a caseworker for just about 10 years. And we're also welcoming Scott Zimberg, Judge Zimberg, who was sworn in March of 2023, and since April has been assigned to domestic relations as well. He currently presides over the call in District 4, which is Maywood. And from 1996 until he took the bench, Judge Zimberg ran his own law practice where he also focused mostly on domestic relations matters. He currently serves as an officer for the Illinois Jewish Judges Association and sits on the pro bono working group for the Illinois Judges Foundation. And he also serves on the board for the Chicago Lighthouse for the Blind. So we have 3 awesome panelists, all of whom have a long history in domestic relations, and we'll be giving everyone lots of insight today. Okay, I think somebody asked to put the hypotheticals in the chat. Everybody should have received them. If you got the email to log in with the Zoom link, then the hypotheticals were attached to that as well. Aviva, are you able to put the hypotheticals in the chat?
Yes, I can do that in just a minute.
Okay, wonderful. Okay, so we're going to cut right to it, and we will leave some time at the very end too if we have time. But for some general questions, if you have those, you can put those in the chat as well, and we'll reserve those for the very end if there's something that doesn't pertain to the hypotheticals, but some other hot topic. So we will have a little bit of end at the end of the CLE. But I'm going to just sort of review the first hypothetical, and it looks like somebody put the hypotheticals in the chat, so they're there.
Someone beat me to it.
Yeah, somebody beat you to it. So they're labeled under revised hypotheticals. So anyone who needs to can go in and download, but I will review them right now, well, as we go one by one. So the first hypothetical really focuses on marital assets. So we have Jared and Sheila. They've been married for 9 years. Jared currently works as an account manager, and he makes an annual gross salary of $150,000. He has retirement assets that are marital of $200,000. Now, Sheila's the CEO of a mid-sized tech company. She has an annual gross salary of $350,000, and that's before bonuses. So her salary can range anywhere, or the bonuses can range anywhere from 50 to 100,000. She's been the CEO for 2 years, and before that, she worked as a finance and science teacher at a community college where she earned $45,000 a year. So big leap in salary. She currently has a 401k. She's got $30,000 in it from her current position. The parties have no children. They've got 3 dogs. And in addition to their marital residence, they've got a vacation home in California and a rental property in New York. They have a lot of valuable collectibles. They've got a piano, art, and Jared is actually the beneficiary of a family trust. His share is valued at about $1 million. The parties are now dissolving their marriage. They have no prenuptial. They file. And Jared wants to petition, or he's petitioning the court for temporary and permanent maintenance. So I'm going to throw this out to Judge Barrett.
Okay. Go ahead.
What do you do in a situation like this where the parties make more than the combined income threshold regarding maintenance payments? And how is it that you would go about determining the maintenance payments?
Well, in this scenario, first of all, good afternoon, everyone. In this scenario, though, if I'm looking at it, the majority of the marriage, Jared was the breadwinner. For 7 of the 9 years, he was making 3 times what she was generating. And the income for the majority of the marriage was approximately $200,000 gross between the 2 parties' income. And they must have been extremely frugal because given the assets they've been able to acquire, the fact scenario did not give a lot of indication as to did he utilize some of the non-marital funds to purchase the vacation home in California and the rental property. And it was only the last 2 years did her income double his. So for maintenance purposes, I don't really believe Jared's a maintenance candidate. However, while the matter is still pending, all the money she's generating and all the money he's generating is marital. She shouldn't have no greater right or access to the 350, possibly 400 to 450,000 in liquid income over his 150. So I would probably give him some money to live on during the pendency of the proceedings and just go from there. But it really depends on who's paying what assets and go from there. But per maintenance after the divorce, I don't see him being a maintenance candidate.
Judge Trowbridge, any other thoughts on that?
Yes, I'm harsher than Judge Barrett is. I'm not giving him maintenance at all. He's got a $1 million trust, among other things. And the standard of living during the marriage was only with her money for 2 of the 9 years.
Judge Simberg?
So I tend to agree with my colleagues as kind of assessment. I mean, I think there's some other issues that would come into play on the big picture, but on the question in number 1, which how would you have a formula when they're under $500,000 combined? There's a formula, and I think one of the questions that I always had as a practitioner is the old way before we had the guidelines, even if it was regardless whatever they earned, was sort of every judge had their own mechanism to calculate the maintenance. So I think in this question, it's sort of how do we deal with it when we're above the guidelines? I think in this case, they're just barely above the guidelines. So for me, whether it's a maintenance case or not, I like to see what the parties are fighting about or like what the issue is. And in this case, so I calculated the maintenance. If she's at 350 or if she's at 400, and did what the duration would be, just to get an idea what is actually at issue, whether I awarded MAID or not. And either way, it was somewhere between $94,000 and $133,000. So that's really what they're fighting about as it relates to maintenance overall. I think that could be used later on when you're talking to the parties. If they're both going to waive maintenance and you want to throw something out there for a credit here and there, that's something you could work with. But in this case, that's what they're fighting about. I don't know how much these other properties are worth. They may have a, $1.5 million to stay with those other properties, and maybe at that point, $50,000 credit here and there gets it to settlement. So I like to start to see where we're at. If it's really, way over the guidelines, then I think you have to start looking at the actual needs of the parties and what their expenses are. If you've got people that have, $1 million, six figures income. So that's how I would go about that first question.
Anyone from the crowd, anybody have any other questions or comments about how they would approach it or how they think a judge should handle it, what they would argue to a judge? Not seeing anything in the comments. Okay. Okay, so I have a question. What if the parties were only married for 4 years? Would that change any of your comments or thoughts about how you'd approach it?
Yeah, because half of the marriage, she was making a substantial amount of money.
Well, was it the 4 years when she was earning 45 or 4 years when she's earning 400 or 450?
That's a great point. I only started with the last 4 years and worked backwards, but you're right. Otherwise, it's a maintenance case for her.
Right. Right. And he'd be stupid then to file. Because it would enrage the judge.
Right. So Brad, you're saying that if there was 4 years and she was making $400,000 for 50% of the marriage, you'd be more inclined to consider the maintenance.
Yes, it's also going to be a very short term.
Right.
I would also look to see when they bought the house in California. Was it after she started generating close to the $500,000? Did they buy it utilizing one of her bonuses?
Yeah.
Right. Another key factor is who's going to get that rental property and how much income that generates, because if he's making less, but he gets property that's generating $50,000, $100,000 a year, then I think that's going to come into play as well. If she gets it, then I think it makes it more of a maintenance case.
Good point.
Unless they were renting the property themselves. I guess the way the fact is written, they could also just be renting property in New York. It didn't say they owned rental property. So I guess the way you can read it either way.
I think if it was a rental property that they were renting, finish the lease and you're done.
Right. I was reading, my answer is based on that they were receiving rent for that property.
Yeah, mine too.
Okay. And then if they were married for 25 years, which would encompass both time periods, when she was making a lot of money, when she wasn't making a lot of money.
I'm more inclined to maintenance for him because that was their lifestyle. I'm really focused on the duration of her earning so much more.
And it would depend on, when she started earning so much more.
Yeah, she was earning that
still
income.
the last 2 years, I would still say probably no. If it was 23 of the 25 years, I'd probably be leaning with Judge Trowbridge.
Yeah, she at a 25-year marriage and she only made this amount in the last 2 years. It's not even a close call for me in terms of not giving him maintenance.
Right. All right. Okay. If the parties were to split up their marital assets, you've already hit on this a little bit, but what are some of the other factors that you would consider when you were dividing up the marital estate?
So, I mean, back to the, if that's a rental property, that's, one of the factors if it's going to generate income, what the values, I mean, obviously the hypothetical doesn't say what the values or the equity in these properties are, but obviously that would be a factor. I was surprised, again, in the hypothetical that she was working for 2 years, making that money and only had $30,000 in her retirement. He has more retirement according to this. And then he also has his trust, which I think would be a factor in dividing the property, because one of the factors is what each party's non-marital property is. And I think that's sort of a quasi property, whether a trust is property or not, or a future interest. But I do think it would be a consideration for me that he has that and he's a beneficiary. But I want to know the terms of the trust, of when he's going to receive it, and then is it dispersed over, a certain period of time, or does he have full go at it upon request?
Yeah, that's a great point.
Yeah, I think the trust is a really key factor in terms of the how it's set up.
Would you? split
I
the
wasn't
estate
concerned
50-50?
about the 30,000 in retirement because he only generated 209 years. You'd have to look at their age and how much what's their max contribution. I'm assuming if they're only married 9 years, she might not have been able to put as much in as she wanted to, given the restrictions on how much you can put in a 401k on your age. Especially with the new law that just changed. It's even gone
So
down further.
So would you split the estate 50-50 or different from that?
Depend on who got the rental property. I think it all comes down to what the rental property is,
What it's generating.
what it's generating.
I think
This
this could,
million in the trust has an impact.
yeah, and I think this could come in again with the maintenance issue. If they were really at issue on the maintenance and nobody was giving in, he was insisting on the maintenance. This is under the 9-year original hypothetical. Then you have about $100,000 average, depending on what her income is, that you're talking about the maintenance is valued at. I think I would use that as a property settlement tool and maybe give a credit in one way or another, or suggest a credit one way or another, and both parties waive maintenance. I don't think he needs maintenance. I mean, he makes $150,000. He has a trust. He gets to rent the property. So I don't think it's like he needs it to pay his bills. It's not like we have somebody at 80,000 and 20,000. But I think it's still an issue based on the factors in 504. So I would probably raise that as, here's the value of the maintenance claim, and can we equalize the property or give a credit to get this case resolved, rather than going to trial on that particular issue.
So I asked earlier, I don't know if anyone heard me, would you start with splitting it 50-50, the estate?
I would start with 50-50.
I agree.
And then depending, when you learn more about other factors, including other assets. Okay.
I also think it makes well, never mind. Never mind.
I'm curious if any of the excellent attorneys on here have different perspective as to what they would be, or disagree with us. I mean, I
would love to hear that, actually.
There is a
I did like the question in there. That's a good
Yeah.
question.
The question's interesting. So Kim Grannon put in the chat, if they were married for 15 years, got divorced, remarried 5 years later, how would you base maintenance? Would it be based on the 5-year marriage from the second go around, or would it be based on the cumulative 20? And I think something Judge Trowbridge said earlier, I think the longer they're married and their lifestyle comes into play, based on her salary, would also, like, the longer the marriage is and the longer she's at that job, would also probably determine a lot of these questions, because then, if he's making half her salary, he might not need maintenance, but maybe there should be a different split of estate.
Yeah.
I
If
would
they-
only go on this scenario 5 years. I wouldn't add the 15. I'm assuming they walked away with an equitable distribution after 15, and they have a 5-year marriage now.
I agree.
Right. And if they waive maintenance after the 15 years, then I think they start new when they get married again. Because I don't know how much time in between, but things could have changed in between the first marriage and the second marriage. So I think 5 years is what I would go with as well.
I think legally you have to. I don't think you can look at it as a total over
Yeah,
20.
I wondered about that. That does not seem right.
Right. Okay, so we're gonna move. Initially we thought about moving into breakout rooms. I think we're gonna stay as a group. I think we're manageable as a group, and then everybody can sort of be interactive.
There was
Oh,
one
wait,
more
there was-
question.
Yeah.
Another question by Catherine.
If the family trust was such that Jared's share could not be valued at a current cash value, what would your answers change at all? So it's a pour over trust from parents who are still living and using the trust, but at some
Possibly.
point.
I
Jared.
don't think my opinion would change as to maintenance. But the distribution of the property, we were starting at 50-50 already, so at that point, to get all 50-50, I think the rental property has a bigger impact on the distribution of the marital estate versus not.
I
I
might
also
consider
think,
maintenance.
yeah, I mean, I think if the parents are using the trust I mean, we don't know when the trust will actually go to him. So
Right.
by the time they are gone, there could be $1 left in the trust. So I don't think you can penalize him for something that is contingent upon the future. I think you have to look at least that's how I would view it.
I agree.
Okay, any other questions on that first issue? Because we're going to move on to the second. Oh, look at this. Now we've got another one. Okay, if you have any other questions on this first issue, now's the time. Devil's advocate question from, I can't see, Scott McDonald. Sorry, my glasses are not particularly helpful right now. Why would the judge consider maintenance at all in this scenario when the marriage was only 4 years? Because it's so short? I think the
Why would
question
we-
was just, would you look, if you were considering maintenance, would you look at it on the 5-year or a total of 20? Not that you would award maintenance.
So I think I have a different approach than Judge Zinsberg. I always like the first question first. It's a two-prong maintenance. Are you entitled to maintenance? And only then do I look at the numbers. I don't really go into it looking at, well, what are we really fighting about? But it's not a bad way to look at it. What are you really fighting about in the long run? And is there a way to get over the issue? A 4-year marriage, this kind of money, $1 million trust, retirement assets, I still would probably be a no maintenance case.
And I think what Judge Trowbridge is saying, that it would just be, rather than 9 years and her having 2 years of that salary, it would be more of a consideration if with half the marriage, their lifestyle was based on her making $400,000, $500,000 a year. I think it may be a stronger case, but again, even if he awarded it maintenance, that's for probably a year and a few months at
Right.
most.
Yeah, that's right.
Yeah.
Right. And I'm sorry,
no,
go ahead. Go ahead, Judge Rosen.
No, I was just going to say, between the two of you, yes, if the case is up for hearing or trial or something like that, I always go to the first question first, which is, are they entitled? But I think, if I'm not wrong, Scott, you're looking at it like, oh, how can we settle this? And looking at it overall, and like, when you're in a pre-trial, you're trying to make recommendations about how to settle something.
Right.
A good
I
way.
mean, I've had cases where they've come back 3 or 4 court dates saying there's an issue, and then even recently I said, did you run the calculations and see what somebody wanted made and somebody didn't, when nobody had run the calculation. So I went back and ran them, and it turned out, based on the schedule, the parenting, they were fighting over $100 a month or something. Like, that's what it turned out to be. And I came out and everybody's faces were like, oh, okay, we settled the case. So I like to look at it, but I agree with Judge Barrett. If it's going to trial, I'm not calculating numbers until I determine whether it's actually appropriate for maintenance.
Okay, moving on to hypothetical number 2. Okay, now we have Hayden and Amber, never married. They have a daughter, Paris, who is currently 12. And Hayden works as a bioengineer, and Amber works as a driver between 2 and 9 o'clock on a second shift. The parties were in a relationship until Paris turned 7. They separated. Hayden lived close to Amber, but now he's moved to Texas in 2022 because of a job opportunity. Paris was 10 at the time that he moved. An allocation judgment was entered. Amber was given the majority parenting time and residential custody of the child. Hayden was awarded extended parenting time during winter break, spring break, summer breaks. Hayden lives with his significant other, Tiffany, in Texas. And Hayden has remained in contact with Paris. Paris would sometimes visit Hayden in Texas. Sometimes Hayden would visit Paris in Illinois. And Hayden's always remained current with his child support obligations. So in 2022 and 23, Paris had 20 school absences, 38 tardies. The following year, 2023 and 24, Paris was absent 23 times and 32 tardies. Her grades were dropping. She had a variety of disciplinary incidences at school. Hayden's consistently checking in with Amber about these issues, but Amber is taking the position that she's got it under control, and Hayden suggested that Paris enroll in tutoring. He would pay for it. Amber said Paris' grades are improving, and by the summer of 2024, Hayden saw that there was no change in Paris's grades, her attendance, her disciplinary incidences. So he hires an attorney, files a petition for allocation of parenting time and relocation of the minor child because of all of these issues. So before the 2024 and 2025 school year commenced, a GAL was appointed to investigate everything. All right, so this time we'll start with you, Judge Trowbridge.
Can I just say something real quick?
Yeah.
The hypothetical was updated slightly. I think you might have been reading. Now it's a there's already an allocation judgment. And
sorry about that.
Okay, I just wanted to clarify before we get into that sort of
Got
discussion.
it.
But okay, yes.
Okay, so there was an allocation, and now we're looking to modify the allocation.
Yeah,
Correct.
exactly.
Right.
Okay, so GAL is still appointed. So
Yes.
Judge Trowbridge, what would your expectations be of the GAL in terms of their investigation? What are you looking for from the GAL?
Well, primarily, I want to understand what's going on with the child. I also want to know why there's so many absences and tardies. Does she have health problems, or is there something that's not really entirely mom's fault? Or is it more related to mom works at night and she's not there with the child? Who's with the child? What is going on with the disciplinary issues? I also want to know what kind of relationship the child has with her father. So I won't go into more detail. I'll let other people talk, but those are the primary things that jump out at me.
Judge Simberg?
Yeah, definitely the initial part of the investigation. I'd want to know the reason for those school issues. Could be a whole myriad of things. It may be that the mother's irresponsible, or that she's doing anything. That could be a very child may have go under some sort of mental health evaluation herself. There could be issues there. There could be physical issues. I mean, I think we need to know why that's happening before we just jump in to the child going, to Texas. So those would be the initial things that I would want to know from the GAL. I'd want to know a little bit about the dad's residence and where the dad lives, just in case we're going to go that direction. So we have an idea if there's a stable environment where the dad is as well.
So I will add, I'm not impressed by the way mom seems to be disregarding the issues, and either is intentionally or well, she's not telling dad the truth. Something's up there.
Yeah, or she's not being full, at least, with what she's sharing.
Or if she's maybe it's worse if she's in denial and thinks things are going to be fine, and they're clearly not getting better.
Judge Barrett?
I agree with everything that Judge Trowbridge and Judge Zinsberg just said. I'd want to also know if the minor child was seeking any type of therapeutic intervention with the disciplinary problems. But it seems like once she turned 11 and 12, it could be also, as Judge Trowbridge, I think it was Judge Trowbridge who said that it could be physical changes just in her getting older, right? That could be having an impact, but I also see what is the impact from after school from 2 p.m. to 9 p.m. What impact does mom being a shift worker have on being able to supervise, make sure everything's getting done, and who's with her after school?
Yeah.
I think those are all really important points. And we have a question, I think, in the chat that's really relevant to this particular question, but would you ask the GAL to go out and do a home visit in Texas to dad? And also, I guess the second question is, why would you appoint a GAL rather than a child rep based on the child's age? So take a poll of the three of you. Would you all ask dad to go out and do a home visit in Texas before you made any recommendations?
I would want the GAL to at least do a Zoom meeting and see the condition of the home. I mean, if the parties were extremely wealthy, and I thought that was an important factor, I may, send the GAL or child rep there. But otherwise, I think it's an expense we should try to avoid.
I would.
My other
Oh, sorry. Go ahead. Go ahead, Bernie.
No, go ahead, Judge Ginsburg, go ahead.
I was going to say, I'd be more inclined if there was some specific allegations by mom about the house or about the area or about something specific that you can't really pick up from just looking on Zoom. But if there's no allegations or assertions about that, I would think a video tour, at least to start off, would be sufficient.
Although she
And I
doesn't
was
like
merely
taking
gonna, it sounds like the issue is during the school year. And given the fact scenario that dad has extensive parenting time during all of the breaks and no issues have come up about the house. I mean, recommendations wouldn't hinder upon whether or not they have a video conference with dad's house or not house. I'm assuming those issues would have been raised. I think the bigger issue is what's going on between school letting out and the end of the day and why she's not getting to school on time.
I think that's a really important point, though. Like when you look at the dad and the time the child spends with the dad, I don't think the house or the home visit, you know, I mean, obviously, if there's a problem, somebody would have brought it up, and the kid was doing just fine until recently. So
Now,
I think that's
if you get to the point where you're thinking of relocation, then clearly an investigation has to be done as to the schools down there, who's at that point, but right off the bat, I don't know.
I was treating it as if we were going to get to relocation. If it's just parenting time, I probably am less concerned.
And then what about appointing a GAL versus a child rep?
I think
I
that
guess
I don't appoint a GAL or a child rep merely based on age in that middle school teenage zone. So I look at the big picture and what information I need. So I don't know what you guys are thinking or feeling about that, but.
Well, I'm going to want to know the financial situation. If there's not going to be a 60410B, if they can't afford it, for example, then I'm probably going to appoint a GL because I need a witness to testify.
Yeah, I would agree. Unless there's like a child's, I mean, 12 years old, sort of like, if you are going by ages, that's sort of like that in between age, like, you know, I think if it's like a 16-year-old, that's clearly, you're more likely clearly to do a child representative versus a 18-month-old. But I do like the ability to have somebody testify and give more of a report as it relates to some of these issues that I need to know sooner than later.
The tricky part comes in is she's 12, and if she is seeing a mental health provider, who's explaining the legal ramifications to the 12-year-old about signing the release? The GAL can't be the lawyer. The judge can't give the 12-year-old advice. The parents, you got to have a 12-year-old being able to make the determination if she's seeing a therapist to speak to the GAL. So, I mean, that's a little tricky.
Yeah.
So, you know, the child understands what she's releasing and what it could be used for. But I would agree, generally, I'd start with a guardian ad litem at first so they could report to the court.
I assume she wasn't in therapy since mom's not got
Right.
any services.
Mom's in
at all.
denial. Right.
Well, I
Mom's
was
in
thinking
denial.
discipline issues probably resulted in some kind of court intervention and someone probably,
Okay.
I don't know, I was going down the dark path of define discipline issues, because mom's not home. So I figured it was discipline issues outside of the house.
I thought it was at
Yeah.
school.
Maybe she's skipping class, those kinds of issues.
Yeah.
Doing big things. Okay, what are your thoughts? Another question on, so the dad's filing relocation, but he's actually not the primary parent for the child. What are your thoughts on that, or how it should be approached, if not by a motion to relocation?
Right. So I had this in a case because the statute says the only party that can file a petition for relocation is a parent with majority time or equal time. So this is really a motion to modify the allocation judgment where you're looking at one of the factors in your evaluation is the distance between the parties, where they live, their homes. I had the exact issue, and then they were self-represented, and an attorney came in afterward to do a motion to reconsider and said I didn't consider the relocation factors. And I said, well, the dad who did not have a majority parent time, he couldn't have filed it, so I didn't have to evaluate the relocation factors. So I would agree, whoever was asking that, I don't think the relocation may be the appropriate motion, but there is temporary relocation that may be applicable doesn't have the same, I don't think it has the same standing requirements. But at the end of the day, I think we're sort of looking at generally the same evaluation if we're going to send the child to Texas. A lot of the factors are overlapping in relocation and modification of allocation, but I would agree that the appropriate motion is a motion to modify the allocation judgment since we already have one.
Do you think we should find out why the child's missing school and absences of tardies? Should we figure out what the issue is? Because what about the issue is maybe the child hates school, and regardless of where she's going to school, Texas or Chicago, or I'm assuming Illinois, she ain't gonna go to school no matter what. The parent sees her get on the bus and just doesn't go to, you don't know the whys. Shouldn't we know what the whys are before? And will relocation fix the issues?
Yeah, I
Well, I
think
think-
for sure.
Agreed.
I mean,
Yes, I think,
Get a
but I think
therapist.
the question is like, what brings it to the courts for us to do that? So, whether it's the father's coming in for something, whether it's relocation or modification of the allocation judgment. But yes, I think I would agree with that, Bernie.
At what point in the process do you think it would be, or would you consider maybe asking for a neuropsych evaluation of the minor child?
It depends what the GAL or child rep tells me.
Like
I
whether
would-
they recommend it?
Right. I
I'm
think that
not
goes to what Judge Barrett's point just was. I would agree. Like, we need to find out what the reasons are for the school problems and being
Yeah.
late. If it's a truant issue versus a mental health issue suspected, I think we need to then go the direction as to kind of what the GAL is telling us.
Would you have any care at all about what the child preferred? Like if the child either said, I'm never leaving mom, or I don't want to live with dad, or like, would that weigh into, how you evaluated it?
I mean, it's one of the factors, so I think it has to be part of the evaluation. The question is, what weight you give it. And so we have a 12-year-old that got to figure out what sort of maturity the 12-year-old has. If there's mental health issues that are suspected, I think it's less, maybe less weight in the overall evaluation. But yes, I would consider it at this question about what weight we give it.
I probably would not give it a lot of weight unless there were allocations that, for example, dad physically abused her when she went to visit him in Texas. Otherwise, I don't care a lot about what a 12-year-old wants.
Kind of look at it the
Ms. Barrett?
same way.
Feel the same?
I would look, it is one of the factors. It's not a factor that we have to rely upon. And we have a 12-year-old for whatever reason is missing school and not showing up on time, and the grades are slipping, and there's a pattern of over 2 years. I'm not quite sure I'm going to give a 12-year-old a lot of credence as to being able to dictate what's in her best interest. Because at 12, did any of us know what was in our best interest?
For
I thought I did.
sure. But I think that all goes back to the why, right? Like from the get-go, it's like get a therapist involved, get the GAL involved, and figure out what is the issue here, what is going on, what's happening. Because once you've figured that out, then you can start making decisions about what best would help this child or put the child in the best situation moving forward. So I think it all ties back to the why, right?
I could imagine a scenario where she wants to stay with mom because dad is more of a disciplinarian and she's
Right.
kind of gotten her way under mom's roof.
Right. Or dad won't make her address whatever it is that's going on. If she is having some mental health issues and dad's like, sorry, but you're going to do the hard work. We're getting into a therapist and whatnot. And mom's like, what? Nothing's happening. I mean, that's a thing too. So, okay. There was a question from Elka Blonder about what if the mom did raise specific allegations at this point about dad's house and they don't have a lot of money. I think the question really is like, at what point do you sort of say, no, we really need somebody to go down there and check that living situation out before we can make a further decision?
I think once the court makes a determination that a modification is going to take place and that it's in the minor child's for the modification, and once you get over that hurdle, are the dad's living conditions and where he's residing, are those going to be in the child's best interest to then go there? Because the court might say, Dad, I'm gonna grant the modification, you're gonna be the primary parent, but oops, you have to live here in Illinois. Right?
Yep, that's a possibility. Depending on the timing of this, I may temporarily allow dad to relocate the child to Texas for summer and see how that goes.
That was actually my next question. Like, while this is all pending, would you consider moving the child from mom to dad to see if it alleviates any of the issues or, if it helps at all?
I would, and for a couple of reasons, but before I issue a final order on this, I want to know that this is workable. I don't want to grant dad's motion to relocate and 6 months later be back in court because it wasn't working.
I would probably, given the fact that it's in the summer of 2024, I'd get the GIL in sooner rather than later. And given that school year is going to be starting in the fall of 20, I would probably grant a temporary relocation depending on what the investigation showed by July. And then let's see if this gets better between the first semester, the first
Yep.
after the school year in Texas.
Yeah, I actually, and our scenario wasn't based on it, but I actually did have something that was similar. The parties were in Illinois, but one was in Chicago, and mom wanted to move out to a suburb, and the child, pursuant to the divorce agreement, was supposed to stay in the city in school. But he was really, really struggling. And there was a therapist involved, and there was a GAL involved, and there was an assessment of the schools and whatnot. And it was just this kid just wasn't, he really, in the summer when he was out with mom and he was playing baseball and on teams and on sports, and he just felt so much more comfortable out there and more comfortable with his friend group. And then the schools were rated a little bit better than they were. And, it was a struggle because they had this divorce agreement and it wasn't that far it wasn't that far in the past. And, but this kid was clearly thriving in the suburbs in this new environment that was whatever it was, 25 miles outside of the area that they'd agreed to live in initially in the city. And so I did let the kid go for first semester, and the kid had some learning issues too. And so the school was claimed that they were really on top of dealing with, learning divergencies and whatnot. So we did let it happen. And I will say by the end of the semester, it was interesting because dad had been very, very opposed to this, and they all ended up meeting with the school and having conferences and the therapists, and the child was really thriving. And the dad came around and said, all right, because it was the best thing to do for the kids. So it wasn't a California, Chicago instance, but it was sort of similar to this scenario in that way. And I did let the kid try out first semester in the other school.
Yeah, changing the school obviously comes up a lot when it comes up middle of the school year. And I think it is tough to change schools like midway, but in this situation, there's just so many absences and tardies. I'd be more open to saying, let's just switch it on the fly and let's see what happens, because, these number of absences and the child having these difficulties, I think is pretty severe. So,
yeah.
Yeah.
And it's been going on a while. It's not new.
For a couple of years.
Yeah.
Right.
Okay. So now last little play in the scenario, but we've got some updates. Paris, her grades, the attendance, the disciplinary issues have not improved while the GAL has been assigned to the case. And Amber has now become uncooperative with the GAL and has sort of tainted Paris and encouraged Paris to speak poorly of her father and the fiance and whatnot. And the child and Amber is really upset. She does not want this child leaving and is really encouraging Paris she's coaching her. Hayden, the dad, has been very active in Paris's school community from afar, but electronically on Zooms and whatnot. And he's really tried to help with her grades and miss school. So how does that play into what decision you would ultimately make about the circumstances?
And I think it makes it a lot easier. We have now we're in court, and the mother has doubled down and turned the child against dad. dad's picked up the some of the slack and is getting more involved to try and get the child on the right path. So, you know, when you're looking at the factors on encouraging a relationship with the other parent and the school factors and the environment, I think mom has made it a lot easier for
Right.
me to make a decision. I will just say, as a practitioner, it was always a lot easier to come in and ask for a lot of things. From this perspective, sometimes it's very hard to suspend parenting time or have children change schools, but it's a lot easier to ask for it. But in this situation, I think it's the decision for me is a lot easier.
Well, and this has happened under your watch, that she's made a decision to behave like this
Right.
when they're in court.
Right. So if each of you had to pick one or two top factors from the statute that you think, obviously you're looking at all the statutory factors, but if you had to pick like your top two, what would be the most important factors that you would each look at or think about?
Parties' ability to effectively communicate and promote a healthy relationship for the minor child between both parties would be number one. Because even under the first part of this scenario, mom was like blowing dad off. It's fine. Dad's offering to pay 100% of the tutoring expenses. No, she's fine. Her grades are better. So clearly, I think that would be a big factor for me. And then what's going on with the minor child would be the second big factor.
I agree.
100%. That's a factor that I think when I'm weighing the factors, I think that's most important to me.
Okay. Any other questions on this? Now's the time to plug them in because I'm going to move on to scenario number 3. Type away if you have a question. Okay. Haven't seen any others for a little bit. So I'm going to move on to the third hypothetical, which focuses on decision-making and parenting time. So we've got Zelda and Xavier. They have 3 kids, Noah, Naomi, and Nathan. Zelda's been the primary caretaker for the majority of their lives. And Noah's 15. So Zelda has not cooperated with Noah's high school to complete the process to get Noah an IEP. Noah has some issues and mom isn't helping get services in place with the school. And that requires an evaluation that's done by the school itself. So Naomi, who's 14, is doing well. She's involved in lots of activities. Nathan is 9. He's had some minor disciplinary issues and he struggles a little bit with math. And Zelda has not enrolled Nathan in tutoring for math or encouraged him to make sure that his behavior is appropriate at school. So during the kids' lives, Xavier, his dad, he moved out of state a bunch of different times. And when he was present, he would visit, but he would leave after several months. So he's not consistent. Zelda and Xavier do not get along. They're often bickering about the kids. In 2024, Xavier returned to Illinois permanently and filed a petition to set parenting time and joint decision-making. A GAL was appointed pretty quickly and to address all of these issues. The parenting time, concerns about the kids' school, the kids' apprehension about spending time with Xavier because of his inconsistent participation in their lives. During the GAL's investigation, the GAL requested many documents and releases from the parties for school records, medical records, releases to speak with teachers and staff, and to speak with the kids' healthcare providers. During the investigation, the GAL recommended a temporary parenting schedule for Xavier for 1 dinner during the week and 1 full weekend daytime, so no sleepovers, and family therapy for Xavier and the minor children. Xavier is asking to be allocated primary parenting time and sole decision-making, of course, and Zelda likes the opposite. So Zelda's continuing to disagree with the parenting time that's in place temporarily. She does not want it to increase, and the GAL has learned the following during the investigation about Noah. So the GAL spoke to Noah, spoke to the school staff. Noah has been on an in-school suspension, in school where he gets counseling, and it requires that a parent signs the agreement to participate. Noah is consistently acting out in class. Zelda fails to inform the GAL or Xavier about any part of the suspension. The school staff informed the GAL that Zelda has repeatedly refused to address the issues, any kind of disciplinary issues. She won't attend a parent-teacher conference. She won't sign the agreement regarding the in-school suspension that can provide these extra services. The GALs talked to Noah. Noah was fidgety, very distracted, and said that he hates school because he doesn't know what's going on in class and the teachers didn't understand him. Zelda is continuously refusing to allow the school's plan to move forward for Noah. She doesn't believe in therapy. Xavier is all on board with all of it, school's recommendations, and thinks that Noah will benefit from even more therapy individually to address the anger in his feelings. Okay, that's a long hypo, but it's a lot of good stuff in there. We will start with Judge Sindberg. What would you order in regards to decision making, or how would you go about figuring out, I guess both, how would you go about figuring out who you think the best decision maker would be? And then ultimately, who do you think you would assign the decision making to? At least temporarily,
Sure.
if not on a long-term basis, but.
So obviously, we're talking about, the 4 different categories for allocation of those those decisions. With the school, with the evaluations, that sort of borders under medical, in my opinion, and school, because it's through the school, but it's also for mental health purposes. So I think it borders on both of those. So just so there's no funny business as it relates to, well, that's not a school and that's school, not medical, or I would probably on an interim basis let dad make those decisions, because especially if the GAL is telling me this child needs these services and mom is standing in the way from anything occurring. I almost feel that if, based on the GAL's observation, the child is showing some signs of potential mental health, anxiety, or whatever the case may be. Obviously, I'm not I can't sit as a medical professional, but this could actually border on a serious endangerment situation. If a child had a broken arm and the mother was refusing to get the child attention or medical attention, if the child has a potential mental health issue that's interfering with school, needs a professional to intervene, and the mother's just sort of blowing it off, I think it actually could rise to a level of serious endangerment. But on interim, I think I would want to get those things going, and I would give dad the temporary right to make those decisions, at least to get things going. Let's see what the evaluation bears out, and then we could see where we're going to go after that.
That's exactly
Judge
what I
Barrett?
would do.
Okay, Judge Trowbridge?
I just answered, that's exactly what I would do.
I would take it one step further. I would also modify the parenting time on a temporary basis as well, because it doesn't matter what dad decides, mom's not gonna follow it anyways. She's not doing what's in the child's best interest, so. And I would even contemplate putting in, Nathan as well. Because the middle child seems to be thriving under mom's care. So I don't know if you really want to separate the two boys from their sister, but something's struggling with the raising of the older and the younger son. So I would probably modify temporary parenting time and decision-making for the 2 boys sooner rather than later.
Yeah, I feel like this comes up, right, where not all the time, but certainly enough where we're asked to make or to separate kids, siblings in a household, because I'm just making this up, but there's a boy in the household and him and mom are really butting heads and he wants to live with dad. But there's other siblings in the house, and that's something to think about too, right? Is that we're splitting up siblings, and how does that impact them as a family? It's not just about one kid or the other kid, it's about all of them. And when you split up the siblings, it can go good or bad in terms of how it affects the family dynamic with a given parent or both parents. So I think that's like a hard thing we have to incorporate that and think about it, but that's a hard twist on facts when we're asked to make that decision.
Great.
Okay. So, and I do think, obviously the hypothetical was set up as such, but, we've got one parent who's Zelda, the mom, who's been responsible and has raised these kids with almost no assistance from dad, certainly inconsistent assistance. And, mom now feels punished because, court's intervening or dad is now back in the picture more consistently and wants some input. But the reality is that dad does have some better judgment in terms of his perspective on what to do with these children, and especially Noah, who's having issues. How would you address it with the parents in terms of how you explain things to them, how you speak to them, how you make sure that, mom doesn't feel slighted and mom is encouraged to behave in a better way that's more in the best interest of the child? Like, how would you address those types of issues?
I think
mean,
what you.
Go
sorry.
ahead. No, go
I
ahead.
would start it with acknowledging and recognizing mom. You raised the three basically on your own while dad was in and out of the state. But as they got older, their needs have changed. And you're starting to see where one child might need additional assistance in academics or socialization. The daughter seems to be thriving both academically and socially, right? But as the older son started to get older, he started struggling with school, struggling with keeping his attention. And it could be that he needs the IEP and mom just letting it go the same old, same old. She's probably tired. So I think I would acknowledge you've done a lot, but his needs have changed and dad seems right now. Dad wants to do it. I think I tried to say, let's give dad the opportunity to show whether or not he can actually be engaged and be a parent and be consistent.
I'd also emphasize this is not intended to be a punishment. It's really, I'm trying to sort out what's best for the child, and whatever we've been doing hasn't been working.
I always try and give everybody a pat on the back, and this is what's happened in the past, but we have a situation we need to confront now. And I would also, I'm not cutting the mother out of the process. I'm letting him make the decision. She would still be, in my opinion, entitled to attend the IEP meetings and know what's going on. So I'm not restricting her from that. And I'm not making any permanent changes. Now we're trying to solve an immediate concern and see where it goes. So I think when we make a temporary order, a lot of times I think the litigants think that's the end of it and they're not going to be able to be heard ever again, and they're very concerned. So I think when you explain it's a temporary change that we're going to do to get to the next step, I think it puts everybody in a better spot.
Yeah.
To some degree, not always, but.
And I would emphasize this, it's more about making sure that he gets these services. I need to know what's going on before I can address bigger picture issues.
So in the parenting time, we spent a lot of time talking about the decision making, but with parenting time, what would you do? So we've got one dinner and one weekend day for parenting time for dad. Dad wants that to continue to increase. Mom is fighting it. What would your recommendations be? What factors would you look at in terms of how you decided to proceed with parenting time issues?
Well, I'm going to listen to the GAL or the child rep, because that's the person who's done the investigation, but I'm very likely to substantially increase dad's parenting time. And I don't know if that's 50-50 or if it's even more. But if he's going to be this involved with getting services for the child, for example, that parenting schedule doesn't work.
Yeah, I think if I agree with what Brad said. I think if we're going to do the situation where we're putting the oldest child or both sons with dad and the daughter staying with mom, we need to work out a schedule so there's some overlap where, when she has her parenting time, all three of the kids are together, so we're not just doing flip-flop back and forth. I think there has to be some time, at least during the week, at least one or two of those days, that all the kids are together with both parents. To make sure that, to Judge Rosen's point, that we're not impacting those relationships as well.
I agree with both of you, and I in this scenario, I would probably put dad as on a temporary basis, that the older son and the younger son with dad maintain parenting time and obligation and responsibility on mom during the school week, because the issues seem to be the weekdays in the schoolwork. And then keep the weekend parenting time where all three children are together. So either all three are with dad and all three are with mom. and go from there.
I want to know from the attorneys if you guys have any ideas or thoughts about what you would do to either for Zelda, for mom, mitigate the damage that she has done while she's been in front of the court, or as Xavier's attorney, what pleadings, you think would be necessary to advance the case, and drop some notes in the chat, and then we can have the judges sort of think about how they would address those pleadings or deal with or feel about the attempts made to mitigate Zelda's behavior, in front of the court. But on a long-term basis, what other things would you guys as judges think about, considering the fact pattern as a whole, to come to an ultimate decision on all of the allocation issues and parenting time issues? So we're moving beyond the temporary, like how's
Sure.
that going to look from temporary to final?
Is dad gonna stay? That would be a huge factor. Is he he sounds like he is migratory in his living arrangements. Is he gonna consistently remain where if you grant it on a permanent basis, is he actually gonna stay in Illinois? Or close to the children if this isn't happening, but.
I'd also say if after the evaluation or the IEP, if they're recommending certain services, is the mother buying into it, and is she going to continue to try and, I don't want to use the word that she was blocking it, but she was not cooperating, at least at the very least. Is she now going to be on board and actually, working with the therapist, working with any type of intervention services for the child? Because if not, then I think that would have an impact as the dad having, more time.
Yeah, I think this is hard. This does come up here and there, right? Or we have this scenario, and I've had a few situations where the mom has then really said, well, I don't want anything to do with my kids. He can deal with them now. I've had that happen a few times, and I find it to be so challenging to figure out how to make mom understand and know how important her involvement is, and make her understand that we're sort of all recognizing that she's got her hands full. And if dad can step up, whether he did or didn't in the past, but if he can do so now and be an asset, then that's really what's best for your kids. I always find it to be like a difficult situation to convey that effectively. So, but anyway, those are my thoughts on it. All right, we haven't had much attorney feedback on this, but we have a little bit. So it says, Linda Jacobs said the split situation residentially sounds chaotic for mom to deal with. She might move to appoint a parenting coordinator, even though the GAL or the child rep are in place. How do you guys feel about appointing parenting coordinators? Like in this scenario, do you think it would be effective or appropriate? Helpful at all?
And I don't think it can hurt, but I'm not sure how much of a benefit on these particular issues it's going to assist the parties. But I think we're a couple steps away from getting a parenting coordinator involved. I don't think we're quite there yet. Maybe after we get the case resolved or get it back on track or know what we're doing with regard to where the kids are going to be. Because we have a parenting coordinator that also may be stepping on the toes of the GAL that we have in the case. So I think let's get this resolved and then see if we need a parenting coordinator. But so I don't think it's quite there yet.
Yeah, I'd focus more on the services and see whether, as I think Judge Barrett said, mom buys in or whether she just holds her ground.
Yeah, I think the attorneys seem to agree, like with, at least from mom's perspective, really encouraging her to communicate, right? If the parties need to go on Our Family Wizard or Talking Parents, but just to show the court that she can communicate and is willing to participate. That's her big issue. So the more she can communicate that she will, and she is able, would probably be more helpful for her. But of course, in the end, we're just looking at what's in the best interest of the child. So, okay, we're going to move on to our last scenario, which is not as involved. unless anybody has any more comments on this one, but I think. All right. Okay, so Rianne and Thornton married 5 years. Before the parties got married, Rianne owned a home. She bought it for $500,000. Now it's worth $750,000. There's a mortgage with a balance of $300,000, and the home is only in her name. When they got married, Thornton moved into the house, and in their 5th year of marriage, the parties used $250,000 of marital funds to make improvements to the home, the land. They built an addition, updated landscaping, things like that, and they updated the whole surrounding area of the home. So $250,000 was for that. So now they're filing for divorce. Do you guys think that the property is still non-marital?
Yes, yes.
So consensus on that. Do you think that Thornton is entitled to any portion of the home's value? And if so, what factors would you look at to figure that out? And what amount do you think you would ultimately give him? So she bought it for $500,000. It's now worth $750,000, mortgage of $300,000, and they put $250,000 into it of marital funds.
So I think the first question is, what were the circumstances of that money? Was it a gift by him from his from the marital estate? Did they intend it as a gift from the marital estate to the non-marital estate? And I think, so, but at the end of the day, though, however, I do think based on the short period of time from that contribution to the day where I do think the marital estate is probably entitled to be, I think the short answer, yes, I think he should get some of that money back for the increase of value. How I measure that, I don't know. I'm not, just because you put $250,000 into the house doesn't mean that increased by $250,000. So I think you have to some metric as to what sort of value that house increased. And so I would give him some consideration for getting half of the money back, I guess, because we're paying it back to the marital estate and it was marital funds. So still half of it was hers that went into it. So I'm sorry for that convoluted answer, but at the end of the day, yes, I do think he should get some of that back on the short period of time.
Would you get it appraised to help you?
Well, the appraisal, wouldn't it be tricky because what isn't the appraisal really come down to what were the 250, what impact did the $250,000 marital funds contribute to the increase in the value of the property? Would the property have gone from 500 to 750 because it's in Burr Ridge in the western suburbs? It'd probably be more, right? So you're really looking at what was the impact of the $250,000, and it might not have had any impact because it might all be aesthetics, but they did include an addition. I'm really not sure how much landscaping is going to do to the value of the property other than curb appeal for a buyer coming to the house. The pond and the water feature, I guess it really depends on the demand of who wants a pond and a water feature in their house. I think the impact would be what impacted 250. Clearly, they enjoyed the updates and they both got the benefit of the updates. I think the whole issue would be what impact did the 250 marital contribution have on the non-marital asset?
I think that's my
I don't
question.
even know who's gonna do that. I don't know who's the evaluator for that.
Yeah, but without an appraisal, how are you going to do that? Unless you're going to hire an expert who's going to come in and try to answer your specific question.
An appraiser could come in and say, without the addition, if the house was as it was then, if it was on the market, it's comparable to these, and I would sell for this. But based on this addition, I think it's worth now, and that's one way to do it. But I think it is sort of a challenging, not specific metric to determine what that 250 that went into it, how much that actually increased the value.
And then do you discount his enjoyment of the property for the years that he lived there? Instead of just saying, okay, I'm gonna give you 50% back, how do you not take into some kind of discount of his enjoyment over the last couple of years?
Agreed.
Definitely. So I think at the end of the day, I do think something should go back to be part of the marital estate. I just don't know what the exact dollar amount is. I think that would be the equitable way of handling it.
I agree with that for sure.
I agree.
The amount, I don't know.
Does it change if he had non-marital money and that's what was used for the improvements?
Yes,
Yes.
Would you give him then a credit back for
I might do
those?
that. I might do that.
But
again,
whether it be dollar per dollar, I think you're back to the same scenario as what impact did his non-marital contribution have to the increase in the value of her non-marital property?
And he got to enjoy the property.
And he got to enjoy the property.
So let's say that there were no improvements. They just lived in the home, but it was, let's say they paid down her mortgage on her non-marital home that they're both living in with his money. How would you address that?
I think he would be, he wasn't living there, he'd be paying rent somewhere else. I don't think he would get any, and he lived in the house, so I don't think I would give him any type of reimbursement there. But on the 250 lump sum from his non-marital, I think you have to look again at if this was a gift, because if it was a gift, I think I don't think I think it's her property. He gifted to her non-marital estate. So
That's true.
I think you're gonna have those battling issues. So and I don't know any other reason. I think it's a gift. I think a gift issue is something to look at.
And what if now they took out a second mortgage and so the home then was retitled in the process of making those improvements? Would you give each of them like a portion of the equity?
And retitled into tenancy by the entirety, she just gifted her non-marital property into the marriage and it is now marital. Now you're looking at, do you give her a disproportionate share for her non-marital contribution to the marital estate? And I think the answer would be yes, but I don't know the numbers and what amount at this point.
I think it's definitely marital property, and I think she should get more than half of its value. I don't know what number I'd come up with.
Yeah,
Unless she did it for the very famous estate planning purposes, so it's not a
Oh,
gift.
yes.
right.
Well, then she's
Right.
gonna need some document, in my opinion,
Right.
to support that. Because I get
I
that.
think that's a
argument.
common defense. It wasn't a gift. It was estate
Right.
planning, but here they got a second mortgage to do stuff on the house. I don't think it was
Right.
that.
I don't think that's gonna be a winning argument.
Right. Okay, what if, last little regroup on or twist on the scenario. What if they bought the home in the first year of their marriage, but she paid the whole down payment of $150,000 with her non-marital money? They titled the home, tenants by the entirety, they both own it. And during the course of the marriage, they both contributed equally to the mortgage and bills, everything associated with the home. So now they're getting divorced. Do you believe the home is marital? I
Yes.
think so.
Yes. Yeah.
And how would you deal with her down payment from her non-marital funds to the down payment?
Depends how long from the time they bought it to the time of the divorce. If it was 20 years, nothing. If it was
Right.
2 years or short period of time, then I think I would consider some sort of imbalance on the division based on her contribution. Again, I don't know how much if that was the only contribution. I don't know if he put anything into it, but I think I'm more inclined to consider it on the short-term marriage.
I think you also have to look at the value of the property, because if she bought it right before 2008, the 150,000 clearly isn't worth 150 because the house value's tanked. If they bought it right before COVID and then nobody can get homes, and the conditions of the economy drove the value of people's homes up so much higher, I don't know if she'd get the 150, but she'd clearly get some percentage of the non-marital contribution. Because what happens if the home value was just stagnant and the only equity in the house is $151,000? Does she get 150,000 back and they split the $1,000, right? Even though they made marital contributions the entire time.
For me, unless it was, as Judge Zinberg was saying, unless it was something like a 20-year marriage, I'm probably gonna give her a disproportionate share.
Give her a disproportionate share.
Correct.
Here's the tricky part. What if the value of the house goes down, they went into foreclosure, or now they owe money at the sale? Who has to pay for the money? Does he have to pay 100% because she brought in the first 150 that was able to acquire the property from it? So is this his way of being okay now? It's easy when there's money left. The problem comes in is when there's a liability left.
It's a marital
Right.
debt. It's definitely a marital debt. I guess, again, what's the equitable way of dividing that debt, depending on what the reasons why it wasn't paid, I guess.
Yeah, I think that's really a determining factor. How did it get there?
Yeah. Well, now is the time. We have a couple minutes left, about 5 minutes. So you can either, if any of the attorneys have a question that's either related to the subjects or just a random, like, please don't use like your own case because we're not supposed to answer those questions. But if you have like a general, question about a hot topic in family law and you want to put it in the chat, or you can just unmute yourself and ask it now. Now is the time for our last 5 minutes. I'll give you a second to do that while I thank Judge Barrett, Judge Simberg, and Judge Trowbridge. You guys have been wonderful, and I really appreciate you participating in the panel for the CLE. I actually think I learned some things, as we all do when we talk to our colleagues. So I hope everybody here has found it to be valuable as well. I do think you'll get a survey, and you need to fill out the survey, I think, to get your CLE credits. So just make sure, right, Aviva? Is that true? I believe that's true. I think you have to fill out the survey to get your CLE credits. So if you want CLE credits, please don't blow that off because then you won't get them. So, right, Aviva, did you want me?
Yeah, shall I start that survey yet, or are you?
No, I think we still have a couple minutes left just to make sure to see if anybody has any questions. I mean, if nobody does, then I guess you can.
I have a general question, if that's okay. Thank you so much, everyone. This was really amazing. My question, which is like totally not on topic of anything we talked about, but in terms of business valuations, so that's something that as a relatively new attorney, I'm still like learning a lot about. And I was wondering if there's ever a case where you would consider the value of the business to be divided and also consider awarding maintenance on top of that if all the income is coming from the business.
So you're saying that the person who's awarded the business also is asking for maintenance?
Well, the opposite. The person who is not keeping the business but is getting an offset of the equity in it. So if I'm the business person, right, and my husband, I'll use him as an example. Like if we're getting divorced and I have a business and we get a valuation and the business is deemed to be worth $100,000. So then, maybe I'm giving him an extra $50,000 out of my house in order for me to keep my business. But he also wants maintenance, and my income is all from my business. And he's already getting a value of the business, which is in theory based on how much income my business is bringing. So I've talked to some business valuators who have said like, well, then it's double dipping and I'm not going to do it. But I've also heard people consider it. So I'm just curious, like what the judges would think about that.
I don't know. My first inclination is that the business is an asset. It was valued. You divided the asset, just like kind of rental property. So if you have a rental property and it's worth, and you buy out somebody of a rental property, but now you're talking about maintenance, I think you have to look at the income you're going to derive down the road in the future from that particular business. So I think that's my first inclination, but maybe Judge Barrett or Judge Trowbridge or Rosen have a different take.
I kind of agree with you. The tricky part is if you both work for the business and you both generate a check from the business and one of you is awarded the business and therefore they're not going to no longer hire their ex to be part of the business. I could see maintenance coming into play then. But I agree with Judge Trowbridge that it's an asset. And then maintenance is predicated on, or Judge Ginsburg, and maintenance is predicated on.
You read my mind and knew you agreed.
Yeah, see, I knew I'd agree.
Yes.
So there's a question, and thank you, Alka. There's a question in the chat about home visits just generally. Some jails always do them. What are your thoughts? My thought is if people are local and there's an issue that's going to involve some sense of like living in the home, then go out and look at the home.
I can't imagine a scenario where I wouldn't want a home visit, to be honest with you. I think that's part of an assessment and evaluation.
Yeah.
I
I'm
think,
kind of
go ahead.
I'm surprised more attorneys don't ask for the home studies. Those home studies are amazing.
Yeah.
The background check and the forensic department runs them. The home visit to me, I think can be accomplished in the the home study. I'm more interested in the GAL's observation and investigation as to the interrelationship between the parent and the children or child. How are they, seeing that and seeing how, and then in the house, or the house, is it clean? They're gonna clean before the GAL comes, right? You would hope. I think the GALs on here could let us know if they don't. If there's someone walks in and the other person's a complete hoarder and the children can't get to the room without climbing up and down property, I would want to see how the children interact with the parents. To me, that's what I want back from the GAL. I'm assuming everyone's been clean, but I agree with you that you do need a home visit.
I don't see why, because why we wouldn't have two sets of eyes if possible. Do the home
Yeah.
visit and have the GL visit.
I think, yeah. I guess there's safety concerns. I think if there's truly a safety concern, I do think that I've spoken to some GALs who have somebody, a security person or whatnot, who will attend the home visit with them. But I mean, part of the job, I think, as a GAL, I mean, it is. I mean, you got to make an assessment. You're the eyes and ears, and you got to come back and let us know what's going on. And we can't do that unless you're able to have a full picture. So, I mean, every once in a while you have two parents and they live down the block from each other and nobody, like the kids are running back and forth between the houses, but they just are arguing about their schedule for whatever the reason is. I mean, is that crucial in that instance? Maybe not as crucial to have a home visit, but I do think when you're going to somebody's home and you're hanging out with them, it's not just about like the cleaning and the looking at the structure, but you're interacting with everybody in the home and you're getting a feel for what it's like to be in that home and live in that home. And I think that can provide important information. Maybe a neighbor comes out with his shotgun and you're like, wow, that's maybe not a safe place to live. I mean, maybe there's a wild animal next door that jumps the fence. And I mean, there's just different things that you can.
Also, if I'm concerned about the safety of a GAL, we have bigger issues than a home visit.
Right. That's when a home study, frankly, probably really be much more helpful and safe.
And Lori, I agree with you. That's exactly what I'm looking for from the GAL. Give me your observations. Tell me what your gut's telling you.
Yeah.
Okay. So I have to log off because I planned poorly. I have a 1:30.
It's okay. It's 1:32.
Me
so
too.
Thank you, everybody. Aviva, if
Thank you
could
guys.
make the.
Thank you.
I'm on.